Colin O'Keefe here for LXBN TV. In a move that's been a long time coming, the National Labor Relations Board's new rulings around what are called ambush or quickie union elections are now in effect. But the fight over them is far from over. Joining me from Columbus to explain is attorney Nelson Cary. He's with Vorys and author on the firm's blog, Vorys on Labor. Nelson, for those who don't know, can you explain the latest happenings with the NLRB election rules themselves? Just, what are they, where are they now, basically?
Sure, Colin, happy to do so. Good to be with you again today. The rules were proposed and published back in December last year, and they became effective on April 14th of this year. Basically, these rules apply to the processing of union election petitions that are filed with a regional office of the National Labor Relations Board. And essentially, in a nutshell, what the rules do is they modify various deadlines, they change various procedures, all with the goal of speeding up the union election process, shortening the amount of time that passes between the filing of a union election petition and the conduct of a secret ballot election by the NLRB.
Very interesting. And I know, reading content from, employment and labor lawyers like yourself, this has been a very big deal, and there's been a lot of hubbub in the lead up to this, but now we're seeing even more afterwards. So, second, what's the status on challenges to this rule? I understand there's more than one here as well.
That's correct, Colin, and there are both political challenges as well as legal challenges. Talk about the political one first because it's really the quickest. Congress passed a resolution disapproving of the regulations, but in order for that to have had effect, President Obama would have had to sign it, but he vetoed that resolution. And so the political challenge went by the wayside relatively soon. The challenges that are remaining are legal challenges, basically courtroom battles. That various employer groups and one individual employer have brought against the NLRB. Those three lawsuits are all pending in federal court. The first one to be filed was in D.C. federal court by the U.S. Chamber of Commerce, National Association of Manufacturers, and some other employer groups to challenge the rule. That case right now is scheduled to have hearings on motions on May 15th, so won't have any decision out of that case for at least another few weeks. The second case to be filed was again brought by some employer groups, NFIB Texas, as well as the Associated Builders and Contractors down in Texas, filed in Texas. The case there actually had motion hearing last Friday, the 24th, on the pending motions to dispose of that case. So we might see something sooner out of that case than we will out of the D.C. case, but again, difficult to predict when the court decides to rule. And then the last challenge, interesting lawsuit filed only last week, essentially very shortly after the rules went into effect. This was brought by an individual employer who actually had an election petition filed with respect to its employees. The employer challenged the actual application of the actual rules and sought a temporary restraining order against the application of those rules to its particular election petition. The D.C. federal judge, interestingly the same judge that's handling the U.S. Chamber's lawsuit against the rule generally, denied that temporary restraining order and consolidated that case with the Chamber's lawsuit and set the hearing dates that I previously mentioned. So a lot of legal challenges still left to it, but difficult to predict when and, of course, what we'll hear from those. In the meantime, the National Labor Relations Board is full speed ahead on enforcing the rules.
Absolutely. It's going to be interesting to see which way those challenges go, but I expect it's going to be a long time before we see some real resolution on those lawsuits themselves, so we'll have to keep track of them, and one way to do so, of course, is with your publication. Once again, that was Nelson Cary of Vorys, and you can read his insight on these cases at VorysOnLabor.com. Thank you for joining me today, Nelson.
Thank you, Colin. Appreciate your time.